Starting with the Universal Declaration of Human Rights, adopted in 1948, the international community created a universal system of human rights protection, for the most part with a control system headed by an international monitoring body, accepting as complaints from states so individual complaints on behavior. Therefore, the regional system of human rights and fundamental freedom were created in the effort to strengthen the respect for human rights. Beginning with the adoption of European Convention in 1950, the trend to elaborate regional standards continued with the adoption of the American Convention in 1967, which was subsequently followed by the African Convention adopted in 1981. Recently, the Asian Charter was established in 2007. Various other international treaties have been elaborated in an effort to render the protection of not only civil and political rights but also of economic, social and cultural rights more efficiently. The historical tradition of thought. There are centuries-long traditions of thought that inspired the creation of the United Nations in 1945. The present system of the United Nations and its affiliated agencies embodied two approaches to the quest for peace. A brief overview of these two traditions of Western thought will help us appreciate not only the delicacy but also the uniqueness of the UN system. The pacifist. The first tradition may be labeled as pacifist ideal, and it includes the body of thought that gave rise to numerous peace projects of the 17th and 18th centuries in Europe. Pacifists generally argued that war is evil, that the greed of sovereign princes or the state system in general perpetuate war, and that the world thus need a supranational political body that could encourage peaceful alternatives to war and when necessary take active measures to enforce peace. The just war theory. The tradition of thought evolved into secular just war theory and eventually into the acceptance of the concept of international law. Just war theorists and international lawyers generally argued that war is sometimes necessary, that states are the only viable units of governments, and that the hope for peace lies in finding conventional limits to war within the system of sovereign states that currently exist. The Charter of United Nations 1945. The UN Charter has laid down the principles of international law of human rights of a general nature. However, on 10 December 1948, the UN General Assembly proclaimed the Universal Declaration of Human Rights. It defines specific rights, civil and political, as well as economic, social and cultural. It declares that all human beings are born free and equal in dignity and rights, and everyone is entitled to all the rights and freedoms set forth in the Declaration without any distinction as to race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. The United Nations Charter precludes the existence of regional arrangements or agencies for dealing with such matters relating to the maintenance of international peace and security as are appropriate for regional action, provided that such arrangements or agencies and their activities are consistent with the purpose and the principles of the United Nations. The members of the United Nations entering into such arrangements or constituting such agencies shall make every effort to achieve pacific settlement of local disputes through such regional arrangements or by such regional agencies before referring them to the Security Council under Article 52. The Security Council. The Security Council shall consist of 15 members of the United Nations, the Republic of China, France, the Union of Soviet Socialist Republic, the United Kingdom of Great Britain, and Northern Ireland and the United States of America shall be permanent members of the Security Council. The General Assembly shall elect 10 other members of the United Nations to be non-permanent members of the Security Council, due regard being specially paid in the first instance to the contribution of the members of the United Nations to the maintenance of international peace and security and to other purposes of the organization, and also to equitable geographical distribution. The non-permanent members of the Security Council shall be elected for a term of 2 years. In the first election of the non-permanent members, after the increase of the membership of the Security Council from 11 to 15, 2 of the 4 additional members shall be chosen for a term of 1 year. A retiring member shall not be eligible for immediate re-election. Each member of the Security Council shall have 1 representative under Article 23. Economic and Social Council. The Economic and Social Council shall consist of 54 members of the United Nations elected by the General Assembly. Subject to the provisions of paragraph 3, 18 members of the Economic and Social Council shall be elected each year for a term of 3 years. Retiring members shall be eligible for immediate re-election. At first, after the increase of the membership of the Economic and Social Council from 27 to 54 members, in addition to the members elected in place of 9 members whose term expires at the end of that year, 27 additional members shall be elected. Of those 27 additional members, the term of office of 9 members so elected shall expire at the end of 1 year, and 9 other members at the end of 2 years, in accordance with arrangements made by General Assembly. Each member of the Economic and Social Council shall have 1 representative under Article 61. Regional arrangements. In the realm of human rights, regional intergovernmental systems have played a major role. The European and inter-American systems have innovative institutions and processes. The African system has distinctive norms, and Arab nation initiatives are at an embryonic point. These arrangements add important ways to an understanding of the full range of techniques and promoting human rights. This arrangement concentrates on one distinctive aspect of its system. The remarkable feature of European system is its productive and effective code. The materials illustrate its work and the dilemmas. Supranational adjudication through its decisions on the right to life and on political democracy, and its response to admission of new members with complex and often problematic human rights records such as Russia. In the inter-American system, the material took briefly at its core but concentrated on its Commission on Human Rights, a powerful organ with tasks and functions not found in the European system. The African system is developing gradually in institutional terms, and we look primarily at the complaint system that has been created. The relationship between universal, meaning in this context UN-sponsored, and the regional human rights arrangements is a complex one. Chapter 8 of the UN Charter makes provision for regional arrangements in relation to peace and security, but it is silent as to human rights. Nevertheless, the Council Europe moved as early as 1950 to adopt the European Convention on Human Rights, and various proposals were made in the early 1950s to include human rights in the frameworks that eventually led to the European Union. It was Not until 1969 that the analogous American Convention was adopted. In the meantime, until the mid of 1960s, the UN remained at best ambivalent about such developments. As Bhasak has noted, there was often a tendency to regard it as the expression of breakaway movements, calling the universality of human rights into question. But he suggests that there was less suspicion of regionalism once the two UN covenants were adopted in 1966. By the time they had entered into force in 1977, the UN General Assembly was sufficiently convinced as to appeal to states in areas where regional arrangements in the field of human rights do not yet exist to consider agreements with a view to the establishments within their respective regions of suitable machinery for the promotion and protection of human rights. The General Assembly Resolution 32/12791977. 4 years later, the African Charter of Human and People's Rights was adopted. Throughout this period, the communist states of Eastern Europe were strongly opposed to regional arrangements, and the Asian and Pacific countries generally argued that their region was much heterogeneous to permit the creation of a regional mechanism. In subsequent years, various sub-regional initiatives have been launched, but few have had any staying power. For example, the states from the former Soviet Union adopted the Commonwealth of Independent States Convention on Human Rights in Minsk in 1995, but it has amounted to little in practice. In contrast, the transformation of the Organization of Security and Cooperation in Europe, OSCE, from an East-West debating forum into an organization designed to promote respect for a broadly defined range of human rights, has added another important dimension to the regional human rights cooperation. Some regional initiatives have also had significant human rights components. In Africa, for example, the Community Code of Justice of the Economic Community of the West African States, ECOWAS, has developed an impressive record in the human rights area since 2005. Similarly, the East African Code of Justice has delivered some important judgments in this area, and Southern African Development Community Tribunal was essentially aborted after it delivered a strong judgment against Zimbabwe in relation to human rights violation. There are strong arguments for a regional approach to human rights, although in some respects of counter-arguments might be also almost strong. One study listed the following factors of favoring regionalism. Number 1, the existence of geographic, historical and cultural bond among states of a particular region. Number 2, the fact that recommendation of a regional organization may meet with less resistance than those of global body. Number 3, the likelihood of publicity about human rights will be wider and more effective. And 4, the fact that there is less possibility of general compromise formulae, which in global bodies are more likely to be based on consideration of a political nature. Innes Claude pointed to some of the downsides. He observed, for example, that intra-regional affinities may be offset by historically rooted intra-regional animosities, and geographical proximity may pose dangers which states wish to diminish by escaping into universalism. He suggested that regional organization might sometimes be too small, in that it may represent a dangerous organizational form of confinement for local rivalries, global stretching, in short, may be no worse than regional cramping. Some commentators, however, are strongly optimistic about the role of regionalism in the human rights regime. Dina Shelton, for example, had argued that the interaction between the principal regional systems and the universal one has led to converging norms and procedures in an overarching, interdependent and dynamic system. In many respects, they are thinking globally and acting regionally. Each uses the jurisprudence of the other system and amends and strengthens its procedures with reference to the existing experience or to the others. In general, their mutual influence is highly progressive, both in normative development and institutional reforms. Before we examine the principal regional systems, we must note the flexibility of the conception of the term region for a range of purposes, such as causes among the state representatives in a UN Human Rights Council. The UN divides the world into 5 geographical regions: Asia, Africa, Eastern Europe, Latin America, and Western Europe, and others, including the United States. But that classification need bear no relation to appropriate definition of regions for the purpose of setting up a regional or sub-regional human rights regime. Thus, Asia and the Pacific may be mentioned by way of example. Consideration might be given to sub-regional initiatives covering the Pacific region, with or excluding Australia and New Zealand, South Asia, West Asia, and Southeast Asia. We turn now to explore the oldest and the most developed of the regional system, the international covenants. The aforesaid declaration carries no legal sanction to compel states to meet the obligation of ensuring observance and implementation of human rights enshrined therein. With a view to improving the global situations on human rights, in December 1966, the General Assembly promulgated the following covenants. Number 1. The International Covenants on Economic, Social and Cultural Rights. Number 2. The International Covenants on Civil and Political Rights. And number 3. Optional Protocol on Individual Petition to the Covenant on Civil and Political Rights. The primary aim common to both the covenants is to confer the right of self-determination of all the peoples in the perspective of civil, political, economic, social and cultural dimensions of the existing socio-legal systems wherein the state parties to the covenants have been imposed with the obligation to promote universal respect for and observance of human rights and freedoms. It also imposes upon every individual the duty towards other community to which he/she belongs and to other individual. From the above analysis and discussion, we may arrive at a point that there are certain issues which are of regional importance and which have to be decided and settled regionally. That is why the Charter of United Nations has made a provision for regional resolution of certain issues which are of regional basis importance. And overall, the Charter of United Nations and all the international laws which we have discussed above will have a relevance, and adhering to those principles, the regional arrangements for the resolution of the issues which are of regional importance and can be resolved regionally can be resolved with the idea of protecting the interest of basic human rights of the people belonging to that region.